Hello everyone and welcome to the Vegas Legal Magazine podcast. I'm Mark Fierro. Vegas Legal Magazine publisher Tyler Morgan is traveling today. Joining us, Fierro Communications Vice President Jeff Haney, also Nevada's acknowledged expert on impaired driving, defense attorney John Watkins, and his colleague Michael Pariente. Thank you so much for joining us today, guys.
Well, thank you.
Thank you.
Our podcast today is about a Henderson resident, Navy Seabee veteran, who served America in Iraq and Afghanistan, Jeff Krajnak. If you haven't heard that name before, you soon will. Krajnak is at the center of a case, the thumbnail of which boils down to this. If you smoke completely legal, recreational marijuana and you drive a car days, even weeks after that, you're breaking the law in Nevada. You could be sentenced to prison if you get into an accident weeks after smoking legal marijuana. You could have your children taken away and your life destroyed. Jeff Krajnak faced up to 16 years in prison in Nevada for doing exactly that. Jeff Krajnak, thank you so much for joining us today.
Thanks for having me, Mark.
First of all, I want to say thank you for your service to this country, and that's not a throwaway line. That means something, and it has everything to do with why we're here today. I want to thank you for your service to this country.
You're very welcome.
First of all, tell us, if you would, how is it that you came to be disabled in service to America?
I did multiple tours to Iraq and Afghanistan. We were hit with an IED one day and changed my life forever. That proceeded to get me medically discharged for the PTSD, TBI, and the onslaught of pain management. So basically, I was medically discharged from the military because of serving my country.
So to put this in context, in the other wars, in the old wars, we had a much, much higher not just casualty rate, but death rate. People died in the field. Now we can save our people's lives, but they are suffering horrific injuries, not all of which are necessarily visible, particularly because of these tremendous blast forces that the terrorists have developed over these last several years. So the VA is flooded with cases like this. How did they treat you in your case?
Medication. They keep on adding pill after pill after pill trying to get it right. They make us zombies, so to speak. So add another pill. If that one don't work, add another pill. And it just steamrolls to adding. I was up to 11 pills at a time.
I want to point out now that the stakes are very, very high when you're talking about this use of medication against traumatic brain injury. Traumatic brain injury has everything to do with this just explosive rate of suicide among our veterans. It's terrible. And these drugs seem to be adding to the problem, not taking away from the problem. Was that your experience?
Most definitely. I myself have wound up in the Spring Mountain facility for 8 days because of suicidal ideology. So it is a real thing. Suicide rate is way too high for veterans, 22 a day, and not enough being done about that.
I just want to ask you one more question, then we're going to have our other guests talk to you. You made the decision to get a medical marijuana card. Was that effective for you? You said zombie. How did that change your life?
I could live again. Like I said, I was on 11 pills at a time.
What were they?
Flexerol, Oxycontin, Percocet, Zoloft, Vicodin, Tramadol, Dioxazepine, you name it, they gave it to me. They switched it around all the time. Propanol, Latropine. It just kept on adding and adding. And the opiates were the big one for me. And that's when I sought out a medical marijuana doctor and got the prescription. And it saved my life. I went from 11 pills down to 2 pills a day, which let me live again. I got my life back, so to speak.
Before the medical marijuana prescription, what was it like on a day-to-day basis? Was it, in other words, was it hard just getting out of bed and just getting going for the day, even on an average day?
On an average day, I would have to drink 3 to 4 Monsters just to move, just to feel a little energy through the day. And like I say, zombie state, it was a zombie state. You had no aspiration to do anything. You sit in your home, you isolate yourself. I call them isolation drugs. You don't leave your home, you don't do anything. If that clarifies.
There comes a day that you decide that you smoke after your kids are asleep. You've got twins.
Twins.
Seven years old.
7 years old, yes.
Okay. And so you smoke after they go to bed. And tell us what happens on this one particular day, the following day, after you used medical marijuana.
That night, I had medicated half a marijuana cigarette at night after my kids went to bed to help my sleep, cut down the night terrors. I knew we had a big day, me and my son. It was a father-son outing at Shadow Ridge Fossil Farm. Every kid loves dinosaurs. I'm being a dad and taking him out there. I wasn't anticipating getting in a car accident that day. We had a planned day, the Fossil Farm. We're going to McDonald's and then going to T-ball, which I was a T-ball coach at the time also. So that was our day in a nutshell. I mean, the accident happened 20 hours after I last medicated.
So you're coming down 95, you're turning off, you're heading south, what would put you right in front of the Boulder Station. You pull into an intersection. Tell us what happens.
I come off the off-ramp under the bridge, and I was gathering some speed. Not a Jeep doesn't go that fast to gather speed, but I acknowledged a car with some ladders and stuff, a truck, in the right-hand lane, so I merged over to the left-hand lane, and at that point, backing down, acknowledging a red light, and my light turned green, so I gradually started picking speed up, and then the impact.
A traumatic, terrible accident. To cut to the chase, the person in the other car, who will eventually come out, it appears as if there's a possibility that he is the person who ran the red light. He ends up dying shortly after leaving the scene. He's not wearing a seatbelt. John Watkins came to the attention of this community in a much larger way. He'd always been acknowledged as a top shelf attorney in town, but came to the community, the acknowledgement of the community in the Jessica Williams case. And the cornerstone of that case was Nevada's draconian per se law. That, what is it, 2 parts per billion in your blood?
That's correct, nanograms.
Nanograms. And they're much less being able to detect it. Does anybody claim that impairs a driver?
Everyone knows that it doesn't impair an individual at 2 nanograms of THC. It just doesn't. In fact, what's interesting is our district attorney, Mr. Wolfson, came out at one point in September 8, 2014, stating that Nevada's DUI marijuana laws need to be changed to reflect the impairment of the driver, not just a standard blood level, according to Clark County top prosecutor. So the standard should be impairment and not some number. And the district attorney recognizes that. This is our chief prosecutor in the Clark County district. So when the prosecutor recognizes there's a problem with having 2 nanograms of THC in your system, that's pretty strong evidence that my argument from day one is correct. I argued this from day one, that this was a draconian law, that it does not get people who are impaired. In fact, the jury in Jessica Williams' case found that Jessica was not impaired, and she's only in prison, and still there, by the way, having the 2 nanogram situation. And then they also have the metabolite, 5 nanograms of metabolite. Okay, at the time of Jessica Williams, the metabolite that they were using was carboxy. That has been changed to hydroxy because, as I argued before the Nevada Supreme Court on several occasions, that the metabolite, the carboxy, is not psychoactive. It has no effect.
It's like a cigarette ash.
Yeah.
It's just a trace that it was
And in
there.
Jessica's case, we don't know that the jury didn't find her guilty of that particular section. So being found guilty of something that doesn't impair. Jessica Williams was a very sad case. As you well know, there were 6 young folks that were picking trash with a bunch of other folks out on the freeway, unprotected by Clark County. And that's a sad scenario. However, Jessica was not impaired.
There were several witnesses who were driving behind her who said she held her lane, that she passed on the left after using a signal, passed back into the right hand. Probably the only driver in Nevada that knows the left-hand lane isn't a travel lane, would go back into the right-hand lane using her directional, and kept her speed, never sped up, passed people very, very carefully, and fell asleep at the wheel. She fell asleep. She fell asleep.
Dr. Chambers made it very clear in his testimony that that was his opinion. She fell asleep. The jury certainly believed that because they found her not guilty of 6 counts of manslaughter, 6 counts of reckless driving, not guilty of impairment. Wow. And only guilty of having those trace amounts in your system.
Michael Pariente, does it drive you crazy as an officer of the court when this young man is facing up to 16 years in prison? The DA, the chief district attorney at preliminary hearings, when asked by the justice of the peace, is he impaired? He's not impaired. He took several field sobriety tests. He was not impaired. For the purposes of this law, he is impaired for child endangerment, but he's not actually impaired. No, he's not impaired, but he's impaired under the law. He's impaired. He had to sit there and listen to that. This is America. It's 2018. This is a legal substance. What do we do?
Well, the problem is the legislature needs to act.
Now.
And they need to act now. And I was hoping something was going to be done this past legislative session. In fact, I believe there was some discussion about changing this to get rid of the 2 nanograms and the 5 nanograms that John was talking about, but that apparently went nowhere. So now we still have the same arcane law on the books.
I see the idea of, when it all seems so very logical. The DA says over and over again, this is just a preliminary hearing, Your Honor, and it is. There's a very low threshold to hold somebody over. But the reality of it is a middle-class person, somebody that's making less than $100,000, $200,000 a year, you're not hiring experts, you're not going to trial, you're not going to prove your innocence, you don't have the money for that. There's no way that the average person can take one of these cases, take it to trial, and prove themselves innocent, is there?
No, you're absolutely right. That reminds me, if I could just take this moment, I was watching this documentary on Netflix called The Staircase. It's a fascinating documentary about a man who was wrongfully convicted. But fortunately for him, he had nearly $1 million to defend himself, and unfortunately kind of had to prove himself innocent, even though we have a system where it's the prosecutor's burden to prove you guilty beyond a reasonable doubt. But unfortunately for people like this man, he's in a situation where he doesn't have the resources to go out and hire a John Watkins or some of the top experts to explain to the jury why you're not impaired. And that's unfortunate. They can't hire persons like yourselves to, focus groups. They don't have those kind of resources. The public defender doesn't have those sort of resources to put into defending people like this.
Jeff, you're on a slippery slope at this point. The first thing that they do is you fessed up to it right at the scene. They asked you what did you tell them?
With their standard question, are you on any illegal drugs or medication? Marijuana to me is medication, so I said yes. I smoked a half a medical marijuana joint last night.
Michael Pariente, if you were on the scene and this is your client, what would you have told him?
Don't answer. Tell the officer right there that you will not speak and that you want to talk to an attorney. And if they continue and they say, well, you have to, this is an investigation, you need to be firm with them and tell them you absolutely will not speak unless you have an attorney present.
Truer words have never been spoken at this table. I'm telling you, with this law, as long as this law is on the books, or as long as you've got anything in your mind that you could be impaired, it's better just to wait for your attorney. Your attorney will do all the explaining that needs to be explained. So, you go to the hospital.
Yes.
You break down when you find that the person in the other car has passed. He's succumbed to the injuries. He wasn't wearing a seatbelt. He dies. Tell us what happens at Sunrise Hospital.
Me and my son go in to get checked out. I was more worried about my son at the time. Airbags weren't. My son got a bloody nose. He was perfectly fine. I had the common seatbelt rash and all that. They sat me down. The doctor came out and he goes, well, he's going to pass. And he just passed. So you're not at fault. Don't worry about it. It was a nightmare for me. I mean, when you're told something like that, your head is all over the place. And of course, I broke down. I felt horrible that someone lost their life in an accident. Not a violent, I'm going to go drive and go try to kill someone today. It was an accident. It was a car accident. And I broke down. Yes, I broke down, and then they administered field sobriety tests.
Now, you pass all your field sobriety tests. There's nobody who says that you're impaired in the field sobriety test. They ask you for a blood draw. You volunteer a blood draw, but they still go to a judge to ask for a search warrant to draw your blood, just as a formality. You give blood, you're good at the hospital, you leave.
Yes.
When do you hear from authorities again?
32 days later, a SWAT team came to my house in full tactical gear, automatic weapons, and slammed me against my wall and arrested me. And mind you, I have no criminal record whatsoever on my background. I don't even have a parking ticket on my background.
A quick step back to the previous step. Did you mention that your red eyes from the crying after being told the bad news about the other driver played a role in allowing a blood test to be taken?
I believe that was written right in his report for his so-called probable cause.
Probable cause was the red eyes from crying after being told the news.
Well, here's another thing, Mark, that's important in this case. Now, I haven't had an opportunity to look at the discovery per se, all of it, but it was my understanding they did what we call the horizontal gaze nystagmus. Yes. And they found that there was no impairment with any of those, those tests, and that should have, clued, the police right there that there's, not impairment. However, keep in mind, here's the problem. This law that's on the books doesn't deal with impairment. It deals with 2 or 5 nanograms. So the police, if they're told that, there's been some marijuana consumed, as though Michael says, don't say anything, well, this, he did. And now you're giving the officer the basis to potentially obtain blood, and since he is a medical marijuana user, he's going to have, the THC, or particularly the metabolites in his system, and so they're going to blame him for the DUI. That's the bottom line. You cooperated at every turn in this.
100%.
Even when they came to arrest you, you were cooperating.
100%.
When they threw you up against the wall, you were still trying to cooperate.
100%.
You go into jail. Here's the irony of all ironies. Again, didn't get in a slip and fall and hurt his head. He didn't trip down somebody's stairs and try and sue somebody. He's on the other side of the world for the United States of America and gets blown up in defense of us, okay? When you go to jail, you can take all the drugs you want, right? They'll put you right back on the very drugs that turned you into something. What was it like in jail? And I'm going to add, to put this in perspective, you're there for 6 months.
Yeah, I went right back to 7 pills. Day 1 in jail. They sit you down with their medical professional and thank you, here's 7 more pills.
And what were you feeling like? What was it like to be inside that body that is now subjected to all of that legal, perfectly acceptable medication?
Once again, the whole jail thing to me was new, so everything was a roller coaster nightmare to me in there. I didn't understand what was happening. I still don't understand. I didn't know about the per se law. I had no clue. I figured being an avid advocate for medical marijuana for veterans also, that if you smoked a marijuana cigarette the night before, you're going to get in this position. I had no idea. So the pills, yes, I would fall asleep at weird times. The beauty of it, when you're getting shuffled off the court, they wake you up at 2:30 in the morning to take your pills, and then they handcuff you at 4:30 in the morning, so you get about 2 hours of sleep before you make your nice court appearances. So yeah, you fit the role of being that person.
Here's another issue I'd like to point out is the bail. You want
Yeah.
to talk about the bail?
Yeah, I was
Michael?
just going to ask you, how much was the bail that the judge set in your case?
The judge set my bail at $250K.
All right, and did she say cash or corporate surety? In other words, if you went to a bail bondsman, you could get out for 15%, or was it just cash? Do you recall?
I don't recall that aspect of it.
Okay, even if it was 15% down, the way it works is, and this touches on what you were talking about earlier, Mark, that when it comes down to it, if you don't have the money, you're really screwed. So in his case, he didn't have the money to post the bail. Now, if you have $250,000 in cash sitting around, well, you can go and you can post that money, and you will get it all back when your case is over. But if you don't have that money, then what you have to do is you have to go to a bail bondsman. The bail bondsman will take 15% of $250,000. I'm terrible at math, which is why I became a lawyer. 37,500 or something. Yeah, I mean, you have to get that. Plus, you're going to have to secure the remainder with collateral. So, a lot of people don't have that kind of money.
You still have to defend yourself.
Right.
And here's another thing that's really, really frustrating and aggravating to me is that we have a presumption of innocence in the United States, our jurisprudence, and that is, you are innocent until proven guilty beyond a reasonable doubt. Don't tell me this isn't punishment by setting a $250,000 bail. The purpose of bail is to make sure, okay, that the person doesn't flee and he's going to show up in court and he's not a threat to the public. Here we have a man that served our country and served it very well, put his life on the line with some very mean people out there, and we punish him by putting him in jail. Now, the reason he was able to make bail, they lowered the bail. It's my understanding.
Finally.
Yeah, when I
Judge
got
Ellsworth.
bound over to district court, Judge Ellsworth said I spent enough time in jail, and she lowered my bail at $20,000.
Everybody should remember that name. Somebody, a grown-up, finally gets in the mix and
I posted bail that day and proceeded to get out 7 days later because I still had to go on stringent house arrest by posting bail.
And there's a real issue about the bail. They realize what you're saying, Michael, is that this is unfair because it doesn't comply with the presumption of innocence. They're supposed to try to revamp this scenario about putting all this money. Bottom line is, it shouldn't be, but if you don't have money to defend your case, you're in trouble.
I want to stay on this point just for 1 second, and then we're going to go back to your case as a whole. But it's easy when you hear a judge or you read in the newspaper, no, the defendant is indigent, he's going to need a public defender. Folks, if you're making $80,000 a year, if you're making $100,000 a year, you can't defend yourself. You cannot defend yourself. I've been doing this for a long time. You can't put together the team. If you do, they won't have a gun to shoot. They need experts. All of these things cost so much money. And in addition, you have to bail in order to participate in your defense. None of these things, every single one of these issues says, if you're smoking marijuana, you never drive a car again. Period. End of story. Until this law goes away, you can't. Before we move on to your case in chief, I want to ask you, you're around other veterans. We hear how hard it is to get off of opioids, how dope sick our heroes get because the VA puts them on powerful, powerful drugs. We also hear that veterans talk amongst themselves and they say that marijuana is a powerful ally, that it quiets terrors, night terrors, that it stops people from having suicidal ideations. Tell us about what you've talked with your fellow veterans about coming off of these powerful drugs.
I call it dope sick. Yeah, you go through your withdrawals, which is a 3-day hell, so to speak. You have sweats. cold sweats, hot sweats, you're throwing up, your body aches all over the place. It is the worst feeling I had in my life. And that's when I decided I need something different. And I chose medical marijuana.
Now, let's go back to your case. Okay, so immediately, as soon as you admit to smoking medical marijuana, it makes a line call real easy. We got our guy right now. You know he's going to come back under the per se law. We've got our guy. But what actually happens in this case is that there are witnesses on the other side. The state only has one witness in their side, and he admits he's looking in the rearview mirror the whole time you're approaching this intersection. But on the other side, one, you've got probably the best trained set of eyes you can, a former military pilot who goes on to be a commercial pilot, and his wife. They're sitting at the light, and they're watching straight across the street, opposed to you. Their light turns when your light turns. The light is right in front of their faces. They see to the left a car coming down. This is the person who soon collides with your car, coming off of the off-ramp. And this pilot, this former pilot, says, it seemed to me that his speed was excessive. It sounds to me as if that person that is driving is speeding up to get through the yellow and possibly red light. His wife says, I don't know anybody that makes these things up for free. She's sitting in front. She can see that her light is green. She's sitting right next to her pilot husband, and she said, oh my God, he's going to run the light. And despite that, despite the fact that they have a witness saying that the other person ran the red light, you end up in jail. Is that something that goes around in your mind while you're sitting there for 6 months?
Yeah, everything goes through my mind for 6 months. Day one in court, I was an endangerment to society, an endangerment to my children, an endangerment to my community, without even talking to me or knowing me or checking my record. I was just an endangerment to the city, to the state, basically. And that bothers me the most. The big one was the child endangerment charge. I had no signs of impairment, and you're saying I put my child at risk? My child's my pride and joy, and I would never, ever drive impaired from alcohol, marijuana, or anything with my children in my vehicle. They're my pride. And to be called these names, even against your children, it is horrifying.
To your knowledge, how many witnesses at the scene were there who stated that they saw you going through a green light, not a red light? And to your knowledge, why were they not permitted to state their opinion on the official record?
There was at least 4 witnesses that were on the green light side.
4 of them, not just one, 4.
They decided to take one phone number. They didn't even retrieve this man's statement at the scene. They didn't bother getting phone numbers or statements from the other 3 sitting there. The phone number they did get happened to be the retired Air Force pilot that thankfully had another witness in his car, his wife. So that ended up with 2 for me because his wife was sitting there. But I guess towards testimony is, well, no one was 100% sure. And that's where that laid. And that confused me also, because if you're conducting a scene, I would think you would want all your information.
I will never understand how they're not 100% sure when they have a witness who's completely uninvolved, who says contemporaneously with the action happening, oh my God, he's going to run the red light, speaking about the person that you eventually hit. I don't see anything clearer than that.
And that's called an excited utterance, by the way, and under the hearsay rule, that's admissible. And why is it admissible is because a person doesn't have time to fabricate.
How are we going to lie about that?
It's a natural, the most natural reaction there is.
It is an observation, and then her husband hears the utterance, and it focuses all of his attention on exactly what it is that she's speaking about.
And I think what you're, bringing out here is what was brought out in the Jessica Williams case. I challenged the law many, many motions, the constitutionality, all denied, denied, denied. And my argument is that to have the law with 2 and 5 nanograms is just inappropriate. You know, it's like punishing someone, okay, who has either, let's say, blue eyes driving a car. If you have blue eyes driving a car, you're guilty of DUI. The same thing. Blue eyes doesn't cause anything. Neither did the marijuana in the Jessica Williams case. And this is the problem, and I don't know why now with the legalization, okay, now you can socially use marijuana. This gentleman actually had a medical card. I think that's even, you know, more favorable to him than he went and just socially indulged, right? Even though the effect, you know, and the results would be the same, but I see that as somewhat different. And we have, the problem is the prosecutors are going to continue to prosecute these cases as long as this 2 and 5's on the book, and it has to go.
And we're going to be speaking with, got a lot of people call the father of recreational marijuana, Tick Segerbloom, is going to be on the next segment. We hope that you'll be back for that as well. We're going to talk about proposed changes and what could be changed. Bring us up to date. You're in jail for 6 months. You get out. You're on bail. You have a chance to talk this through with your attorney. And the reason that you take this plea, is because they could have put you in prison, away from your wife, away from your children, away from your home for 16 years. Do I have that right?
That's what I was told, yes.
And so you enter a plea based on?
I entered a plea because if we took it to trial, like Mr. Watkins said, the per se, they were going to hammer on the metabolite. I was 8 times the legal limit on a metabolite. I'm 33% body fat. Metabolite stores in my body fat. It does nothing for impairment from all my studies, but to a jury, all they are fighting is 8 times the legal limit of a metabolite. That's the big deal here, and that's what I'm trying to help change, is this per se, because it is ludicrous. It makes no sense. And like you stated, you smoke 1 medical marijuana joint or 1 recreational joint, you are DUI up to 7 days in this state. You smoke daily, 30 days. You smoke a wax, 40 days. You are DUI, driving under the influence in this state, and it makes no sense.
Can even be longer than 30 days. It can be as long as it's stored in your fat, because it's a non-polar substance, meaning marijuana, so it goes into the fat. And so when your body uses that fat, it dumps that THC back into the blood. So it can be much beyond, 30 days. Now, here's another thing I wanted to point out. I'm known as a defense attorney, and I'm very proud of that. And I always carry my Constitution because I truly believe in this document. This is what makes America great. And so I was a prosecutor. I prosecuted DUI cases, and at the time, alcohol, drugs, marijuana, we had an impairment. If you're impaired, it's going to show.
Time to go to jail.
And if you're not impaired, you're not going to win your case. There's no difficulty proving an impairment case. This was all a, the reefer madness scare that came on, that we got the 2 nanograms and the 5 nanograms, and somebody was as a young person that was killed by someone who had used marijuana, go to the legislature, and next thing you know, we got reefer madness all over again, and 2 and 5 nanograms. And the Jessica Williams, the reason they denied the law being unconstitutional, Jessica Williams, because it said there was no such thing as legal marijuana. The Jessica Williams decision is no longer a binding authority. We now have lawful marijuana. We now have medical marijuana. So the case should be defended and pointed out that Williams, the rationale in Williams, don't apply anymore.
The metabolite was included in the law to act as a tracer to show that you had done something illegally.
Yes.
It has no impact, has no psychoactive property whatsoever.
That was the whole basis of their decision, because there's no legal marijuana usage in Nevada. That's all gone.
In addition to being the impaired driver expert in Nevada, you handle a huge number of DUIs. Let me ask you this. When somebody's had a couple of drinks and the trooper, the officer goes, I know this guy's had a couple of drinks, how often does that person pass the field sobriety test?
Field sobriety tests were designed, and by the way, I don't call them field sobriety, they're roadside exercise. They are designed to fail.
That's what if you
example,
take
Mark,
that test, you're going to fail.
For example, the walk and turn, and Michael and I go through this all the time, is that there's 93 opportunities to get a mark against you. If you get 2 marks out of 93, you have not passed that test.
Going to Hooskow.
So you can be 98% perfect and you go to Hooskow.
And I just want to add one thing too. The tests are extremely subjective, and science has borne this out. There was a study done by a professor named Spurgeon Cole with Clemson University, and what he did was he had a number of police officers watch other police officers on video administer these tests and ask them to determine if the person passed or failed. These subjects, police officers, watching other officers give these tests, they got it wrong 70% of the time, saying that the person was impaired when they weren't. And that's the problem with these tests, is they're extremely subjective.
So my point is, even though the bar is set so high to pass these field sobriety tests, he passes. He passes.
But what more do you need?
One of the most brilliant defense moves, and I worked the Jessica Williams case with John all those years ago, and one of the most brilliant tactics I've ever seen was that Jessica, as you pointed out, was just lost. She was crying her eyes out on the roadside. And she was not on her knees, but she was sitting on her haunches on the roadside, which was uneven. And you ask the trooper, how long did she sit there like that? He's, a few minutes. She didn't fall over. She was that well balanced that she could hold her balance for all those minutes and never fall over, even though you say she's impaired. Well, she wasn't impaired. She was impaired under the law. Something has to change here. And I hope, I pray that it is your service to this country that makes you, and I don't want anybody to be a poster child, but it looks like it's fallen to you, buddy. And I hope that service is what helps push this case, push you along, and push this wrong that's being done. And I got to tell you something. This isn't Steve Wolfson that prosecutes you. Steve Wolfson isn't going to put you in prison. The people of the state of Nevada are going to take somebody who served their country, and they're going to put that person in prison for up to how long now that you've pled?
No, I pled guilty under Alford Clause to a felony B reckless driving, which carries a 1 to 6 probationable. So I can get anywhere from 1 to, with the 40% off top, I think it comes out to 2.5 years. So.
Okay. If you say it fast, 2.5 years doesn't sound like, but 2.5 years is enough to ruin anybody's life.
Do 2 days in jail and see how you like it.
See how well that goes for you after sitting there as you did. And TBI injuries, they don't go away by themselves. This isn't something that you can talk through. This is a proven physical ailment that has everything to do with tau forming in the brain. It's as much as taking insulation off of a cord and saying, why doesn't the television work anymore? And so it's fallen to you, and I hope that there are attorneys listening. I hope there are people of goodwill listening. I hope the DA is listening. And I hope most of all that there are some Nevada state legislators who will open their minds to the possibility that this is being done in the name of the people of the state of Nevada, and that we're just not going to sit by and let this happen.
Mark, I think Michael wants to.
Yeah, just
explain.
wanted to address when he talked about an Alford decision. And the Alford decision means that you're pleading guilty not because you, in truth and fact, are guilty, but that you don't want to run the risk of being found guilty if you go to trial. So he's not saying that he's not in any way admitting he did it. He's just saying that he's pleading guilty pursuant to this plea agreement because he doesn't want to run the
avoid
risk.
a harsher penalty.
And
Exactly.
in essence, saying that he knows that the state can prove its case because in this case, all the state has to prove is that it has some minuscule amount of fallout of use, not the psychoactive part of the drug, but literally a marker that scientists use to prove that it's been consumed in the past.
Isn't this amazing that you can take these opioids, which we know are very devastating, impairing, but you say, make a doper out of you, and you would have to be impaired before they can convict you. There's no numbers. But in marijuana, we got the 2 and 5. It's just an equal protection violation all the way around.
If you care about this issue, you got to get involved. We can't do this to this young man.
Right.
With that, we call it a day. The Vegas Legal Podcast. I want to thank you, Jeff Krajnak, John Watkins, attorney Michael Pariente. This is not the last time you're going to be hearing about this case on the Vegas Legal Podcast and in Vegas Legal Magazine. We're writing a column, the Court of Public Opinion, for the next issue of Vegas Legal Magazine. We'll follow up on this case also in the fall issue of Vegas Legal Magazine. We'll continue to speak with experts on this topic, asking how is the people who legally use marijuana are not legally allowed to drive for weeks. How can that be? That's a question you should be asking yourselves as well. Also, we're going to be talking to the father of legal marijuana in Nevada, State Senator Tick Sagerblum. He'll be joining us. We hope you'll tune in for that one as well. If you care about this topic, you can share this podcast on Facebook. Tell your friends about it on iTunes and Stitcher or on Vegas Legal Magazine's YouTube station. Thank you.